God save the Commonwealth of Massachusetts. Court is now open. May you be seated, please.
Thank you.
SJC-11292, Madam Clerk-Magistrate, Office Powers.
Okay, Mr. Haley? Before we begin, I would like to say that Chief Justice Ireland will not be available to attend the oral argument in the first 3 cases this morning. He is still a member of the panel. He will review the tapes of the oral arguments and will participate in the deliberations on the case. Mr. Haley.
Thank you. Justice Spina, members of the court, may it please the court, my name is Peter Haley. I represent the respondent, Robert E. Powers. With me in court this morning is Mr. Powers. This matter is before the court on the report of the Committee on Professional Responsibility for Clerk of Courts, dated September 26, 2012, recommending that this court exercise its power to remove Robert Powers as the Clerk-Magistrate of the Barnstable District Court in accordance with its powers under Section 4 of Chapter 211. The removal of Mr. Powers is not required for the public good in this case, and his removal would be an inappropriate response to the facts of this matter. The committee has failed to follow its own rules and procedures as promulgated by this court, and in doing so has deprived Mr. Powers of the due process rights to which he is entitled.
How is Mr. Powers prejudiced?
Mr. Powers was prejudiced, Your Honor, by his inability to respond to the committee at the time that the charges were made.
Why is that prejudicial here?
It's prejudicial in this instance because Rule 7b acts much like an arraignment does in a criminal process, where the respondent has the right to hear the charges against him and respond in the first instance to the committee. Furthermore, as the committee's counsel itself argued to the committee at the time of the hearing before the committee, Mr. Powers, one of the arguments that the committee made at that time was Mr. Powers had never apologized to the committee. Well, the fact was that Mr. Powers was never offered that opportunity to address the committee and to respond to the committee in accordance with Rule 7b.
You agree that the committee, of course, could have proceeded without an informal or a meeting, correct, under 7F?
There were 2 processes by which the committee could proceed without such a meeting. 1, Mr. Powers voluntarily waived that right, which he did not, or 2, pursuant to Rule 7F, where if the committee found that there was a matter of urgency and an emergency requiring the immediate action.
I don't see urgency or emergency in 7F.
The words emergency or urgency are not in the rule. The court is correct in that, in noting that. However, what 7F speaks to directly is the fact that if immediate action is required, the committee may issue formal charges at any stage in the proceeding if there is clear and convincing evidence requiring the removal of the clerk at that time. Here, the committee has not argued that it proceeded under Rule 7F. It clearly did not proceed.
It goes to the issue of prejudice, though. The committee could have. And if one takes the findings made by Judge Dorfer, there was certainly plenty of reason for the committee to proceed, plenty of evidence on which they could have exercised their authority under 7F. It really goes to the issue of prejudice. How is he prejudiced here?
Your Honor, he's prejudiced by the inability.
Notice, there's no due process. You keep saying due process. He had notice of the charges. He had an opportunity to be heard.
Your Honor, the fact that eventually he had notice and the opportunity to be heard does not remove the fact that the due process rights accorded by Rule 7b are there for a particular reason. Much like in the absence of an arraignment, the party, the Commonwealth or the state may argue that it didn't matter. Eventually the outcome was okay. As observed by the court, the Supreme Court in Goss versus Lopez and in a Superior Court decision that we've cited, Ding versus Paisan, the issue is not whether ultimately Mr. Powers would have lost anyways or should have been removed. It didn't matter. It was justified after the fact. The issue is, was Mr. Powers afforded the process which he was due? That process was meaningful in this instance because it afforded the respondent an opportunity to address the committee, to address the charges that were made against him, afforded him appropriate notice, and most importantly, as argued by the committee counsel itself, it afforded Mr. Powers an opportunity to express to the committee his response to those charges at a time. Rule 7b was put there by the court to facilitate these types of adjudications and to offer the respondent the opportunity to reach an adjudication outside of the court process.
When you, at the point where Mr. Powers did appear before the committee, and you just said that prosecuting counsel argued that he never apologized before, right?
Correct, Your Honor.
Did you, I assume you responded to that at the time?
Your Honor, there was no rebuttal argument before the committee. I had already addressed the committee on that morning, and so I did not have the opportunity. I had at a number of occasions in the proceedings and in my argument to the committee that morning had expressed Mr. Powers' contrition.
So this goes back to the question of, okay, assuming that there was a non-compliance with the procedural rules that have some substantive meaning, if the same point could be made, I'm just a little lost on the prejudice question. You just think that if that had happened before, who knows what would have happened in terms of resolving this?
Your Honor, it's much like at the conclusion of the trial, the court says, okay, we forgot to arraign you. You know what? Let's do it now.
That's a bit different. But.
In this instance, Your Honor, my argument, and perhaps exaggerated by my metaphor, for which I apologize, but in this instance, what happened at that time was that the hearing officer had already made his findings. The committee had already reached its conclusions. They were colored by the report that they had received. Had Mr. Powers been afforded that right at the time that it was provided for in the rules, it would have afforded him a substantive and real opportunity to resolve these matters before the committee and to express to the committee the very sentiments that their own counsel argued were absent in this proceeding. That may have had a substantive and important impact for Mr. Powers, and for those reasons we believe that the committee's failure to abide by the rules and afford Mr. Powers that right was prejudicial and important in this instance.
Let's assume you're right as to that point, and put aside Mr. Powers. Let's assume you have a situation in which the exact same thing happens here, but there is devastating evidence that a clerk should no longer be a clerk. What is the remedy for the error that you describe?
Your Honor, in any instance where there is such devastating evidence, then the remedy is that the committee can, on its own, act in accordance with Rule 7F, or can simply afford the respondent that right.
After the fact?
Can afford the respondent.
What are you saying should happen here? I'm a little bit lost here. I mean, here we've already had the hearing officer. We've had a lengthy hearing. We've had deliberations by the clerk's committee. What do you say again? Assuming you're right, what's the remedy?
Your Honor, I would argue that the remedy is to vacate the findings that have been made because they've been made without the due process protections to which Mr. Powers has been afforded. That is a drastic, to the Court's point, a drastic response to the issue here. But the 14th Amendment and the rights of due process are frequently the types of things that result in a drastic response.
This goes to Justice Corey's question. You see this as a constitutional matter, not a rule matter?
Your Honor, the respondent believes that it is a constitutional matter, that he has a due process rights as recognized by the appeals court decision in Fontana and other situations. The respondent has a position to which he's been appointed by the executive officer of the Commonwealth. He has a position of employment. He has certain rights that are attendant to those as conferred upon him by the governor, and he has due process rights in that position. And those are rights which are recognized by this Court's rulings and the rulings of the appeals court to afford such protection.
Did he actually request such an informal meeting?
He did request such a meeting, Your Honor.
And what was the response?
And the response was that he was not entitled to one. The same response has been articulated in the brief.
You actually came up here at that time, right?
I did, Your Honor.
Yeah.
I filed a motion before this Court.
I'm just underscoring, this was not something that you thought of later.
No, I did not think of this in the last week, Your Honor. I've been making this argument for some time, to no avail until this morning. But with respect to the other points that the respondent seeks to make this morning, the respondent also argues that the findings of the hearing officer in this case were clearly erroneous and unwarranted, and finally, that the sanction of removal is inconsistent with the response of the court to the acts of other public officials which it has considered for removal pursuant to Chapter 211, Section 4. With respect to the issue of the findings of the hearing officer, the court is clear that it will not disturb such findings unless it finds that they are clearly erroneous and unwarranted. In this instance, they are such. And the reason they are is that the hearing officer had before him the testimony of some 37 witnesses, all presenting disparate points of view. But importantly, only one witness before it was someone to whom Mr. Powers was directly responsible, and that was Chief Justice Linda Conley with respect to her rights and obligations in overseeing the district courts. Judge Conley testified and was asked, in your opinion, does the conduct of Mr. Powers justify his removal from his position? Can he, in your opinion, continue to effectively serve as the clerk-magistrate of the Barnstable District Court? And her answer was, I can't answer that. People change. He may be able to do so. And in fact, Judge Conley also testified that in her experience, it takes up to 5 years for a party to become acclimated to and learn to undertake the duties of the clerk-magistrate, and that the most effective means by which to judge or evaluate a clerk-magistrate is by observing him in the courtroom.
Now, but I gather you're not challenging the finding that he did not show up for work on time, that he was consistently between an hour and 2 hours late every day.
We are not challenging that, Your Honor.
And is that not, I mean, isn't the first obligation to show up?
The Canon 3 of the Code for the Clerks is direct that their obligation is to devote their full time during normal working hours. And there's no question that for some period of time, although Mr. Powers was putting in a full 8-hour day, he was not showing up by the time that the court convened at 8:30.
And that was the busiest time of day, wasn't it?
The arguments were, Your Honor, that that was the busiest time of day, and there was testimony from some of the clerks that that was the case. There was other testimony that Mr. Powers, who was conducting 400 to 500 hearings, clerk-magistrate hearings a month, also had other busier times of the day, that he stayed well past the closing hours of the court to work on the decisions that he had to make in his role as clerk-magistrate.
Correct me if I'm wrong, because maybe I'm not remembering right, but was this the particular charge that the I thought that Judge Dorfer ultimately said, yes, that was true, but that is something he has corrected.
That's correct, Your Honor. All of the witnesses who testified, including Judge O'Neill and others, testified that Mr. Powers has, since that time and since his suspension in May 2011, been appearing at court regularly on time, and since this court's appointment of him to a position in the Taunton District Court at the direction of Judge Conley, he continues to appear at work at 8:30 on time and has been present during the full and normal hours of the court. The issue of Mr. Powers being late goes more substantively to this court's response and whether or not the appropriate sanction is a sanction of removal. The court most recently considered the removal of clerks in two cases, Duggan in 1993 and Antonelli in 1999. Those cases are instructive for their facts because, as the court has observed in connection with the discipline of attorneys and others, although the court is not bound to do the same thing in each case and considers each case on its merits, the court is instructed by its response in similar situations. Duggan and Antonelli are notable for two reasons. One, they stand out from the other decisions, prior decisions of the court removing a clerk officer or a public officer because most of those decisions involved insanity, incompetence, conviction of a felony. In this instance, in Duggan and Antonelli, the conduct is notable and distinguished in this case for two reasons. One, with respect to Duggan, the first two observations about the clerk were that she kept a special list of favored litigants, and she would treat them differently with respect to their civil motor vehicle infractions. Secondly, that because of a personal dispute she had in her role as an executor of the will, she improperly used her influence as a clerk-magistrate to, in essence, wreak revenge against the lawyer representing the other litigant by putting all of his cases to the bottom of the list. With respect to Mr. Antonelli, the allegations were that Mr. Antonelli improperly used his power and his position to try and influence proceedings against him personally. He was confronted by court officers. He picked up the phone to call Judge McGovern to ask her to intervene on his behalf, and it was clear from his statements and others that he acted improperly. In both Duggan and Antonelli, and consistent with this court's other opinions, there's a clear wrongdoing. It's not a question of, were you late to work, or did you miss the time standards, or did you act intemperately on occasion? The three issues were at issue in this case. It's an issue of, did you use favoritism to affect the administration?
You're suggesting that the Antonelli and the Duggan case are markedly different from this one, and you refer to occasions of intemperance. That's not what I see from these findings. I mean, the word bullying isn't used, but I see persistent pattern of behavior, as found by the master here, of real, not intemperate behavior, just completely inappropriate behavior, not becoming a person in a public position in the way that that person was found to be treating members of the public and those who worked for him or with him. That, are you minimizing the importance of that kind of behavior as found? I know you take it, you challenge some of it based on disputes that you have with the basis for those findings. But if those are correct, how do you suggest that that is not as significant as the other kinds of behavior? Different, but important nonetheless for a public official.
Very important, Your Honor, and I do not seek to minimize that behavior, nor has Mr. Powers. He has apologized for that behavior. He has recognized the instances in which it is wrong, and he has stated so. However, I do believe that it's appropriate to judge that behavior in the context of, did he do this every day and in every hearing? It doesn't make it right in any instance, but it may guide the court with respect to the appropriate response. If clearly somebody acts intemperately in one instance, that's not going to result in a removal. I'm not arguing that it was just one instance in this case, but as the court observed in connection with the decision it made with respect to Judge Lopez, all presiders are entitled to some measure of humanity. In this instance, the testimony overall, if you look at it, are that everybody who appeared before Mr. Powers regularly, on a regular basis in court, testified that he acted appropriately. All of the witnesses presented by Mr. Powers who were in court with him every single day said, I didn't see any intemperance. He acted appropriately. And the one or two witnesses who actually observed him in court, notably Attorney Manning and Attorney Leveroni, testified that I had a problem with him, and those were problems that occurred early in his tenure. But after that, Attorney Manning notes that after that instance, he behaved appropriately in all circumstances. All of the witnesses testified that after the period of his suspension in May 2011, even Judge O'Neill, who clearly is not an advocate of or a fan of his behavior, testified that after May 2011, Mr. Powers is acting appropriately. Clerk-Magistrate Abro, who Mr. Powers works for now in Taunton, testified glowingly about his abilities. Judge Julian, the same. The people who saw him, if you divide a line down the list of witnesses where one litigant had an issue versus the people who are with him every single day, testified that his behavior was appropriate. It doesn't mean that in an instance where a public official or a clerk speaks intemperately to a party or says something that's wrong, it doesn't mean that that's right. And Mr. Powers does not argue that, nor do I this morning. But it does mean that in the context of this court's response to such behavior, the overall record of Mr. Powers should be judged, and the behavior should be judged in the context of that record. For the reasons I've argued, Your Honors, we would ask that the court not remove Mr. Powers from his position in response to the report of the committee.
Thank you, Mr. Haley.
Thank you, Your Honor.
Mr. Bean, would you please turn the clock in front of you facing us so that we can see the time? Thank you.
May it please the Court, my name is Thomas Bean. I have had the privilege of representing the Committee on Professional Responsibility for Clerks of Court for the past 19 months. With me at council table is Robert Langlois. The question before this Court is under Chapter 211, Section 4, whether there is sufficient cause for Mr. Powers to be removed from the office of Clerk-Magistrate and whether the public good so requires that he be removed. Before applying those standards to the particular facts of this case, it's important to remember the role of the court and the clerk in the administration of justice. In words that remain true today, this court wrote almost 50 years ago in a case involving the removal of a clerk. Our function is to ensure the integrity of the judicial system, which must not only be beyond suspicion, but which must appear to be so. The duties of a clerk are performed, for the most part, under public scrutiny. He is a conspicuous figure in the courtroom. He is seated prominently near the judge, where he is in frequent consultation with him, as well as with various lawyers. He administers oaths to witnesses. In our opinion, it would be incongruous to hold out as clerk one who has not conformed to the standards essential to every court.
Now, if I could ask you about a point you made, in attorney cases where we deal with discipline, we focus on proportional conduct and look to comparable cases for other attorneys and attempt to impose discipline that is in keeping with that assessed against other attorneys. Are you saying we should have a different standard here with regard to clerks?
I believe the court has already established a different standard. In Dugan, the court wrote, simply because there may be cases not under Chapter 211, Section 4 are of no help to us. The court wrote, just because there may have been clerks who have committed more egregious acts than the clerk before us does not mean this clerk should not be removed. This is a facts and circumstances case, the court.
But in Dugan, there was no reference to a finding by this court that more egregious conduct would not result in dismissal. I mean, that seems to be like say that there may be somewhere that somebody did worse. But I don't know of any case in which, with regard to Dugan, we saw more egregious conduct and didn't call for the person to be removed. I'm just trying to figure what the principle is that would not have us look to comparable cases. And I guess the next question is, are there comparable cases here?
Maybe I misread Dugan, Your Honor, but my reading of Dugan was that the court's review of whether to remove a clerk is an individual facts and circumstances case. The court has plainly enunciated in the Code of Professional Responsibility for Clerks of Court the standards. The preamble to that code says this establishes the norms of practice. And so I think, what's going to happen in individual cases are going to vary in terms of which rules clerks may be violating and not. And people can disagree about what's more egregious than other cases. But the point here is each individual case must be evaluated on its merits. At least that was my understanding of Dugan. And evaluating, has the clerk violated those rules? Questions, factors. I can see factors the court's establishing. Did the clerk evaluate the rules? During what period of time did the clerk evaluate the rules? Did the clerk have an opportunity to remediate his or her conduct? And in this case, we have multiple rules that have been violated willfully and continuously for over 4 years. We have judges, the presiding judge of the district court, the regional administrative judge, and Chief Justice Connolly met with Mr. Powers over half a dozen times in an effort to help him remediate his conduct. And the response to all of this, Mr. Powers' response is, I've done nothing wrong. To this day, he still believes, this is a whole question of remediation, to this day he still believes it's debatable whether he's supposed to be at work at 8:30 in the morning. Still believes it's debatable. So testified before the hearing officer. He still doesn't think that he was inappropriate in his behavior with the witnesses. He simply thinks his conduct fell below a standard. I don't think that's what the rules provide. As I said, the court said the rules plainly enunciate in Bulger the standards for clerks. And there's no question here that Mr. Powers repeatedly, willfully, continuously violated those standards. But going back to your question, Justice Gantz, I think it's a facts and circumstances test. In each individual case, we don't have a lot of law in terms of application of the rules. The Dugan case was decided based on some conduct before the rules were adopted and some conduct after the rules were adopted. And then we have Antonelli, which was based on violation of the rules. And if a clerk consistently, again, these are factors, and I don't know whether the court wants to articulate it as a standard, but I can imagine there being factors. How many rules, for how long, efforts at remediation, opportunity to correct. I can see those being factors that could be enunciated to say in evaluating whether we're going to remove someone. But at bottom, yeah, I think it's a facts and circumstances test.
Mr. Bean, at the end of the decision of Judge Dorfer, he says, you know, his finding or his recommendation is removal, but suggests maybe the court could do something. He just can't go back and be the clerk of courts. Do you see that as an option?
I don't. Mr. Haley said, well, let's go to the findings, and I'll go to what Mr. Haley said. In the findings, Judge Dorfer said that Mr. Powers has lost the confidence of the staff in the Barnstable District Court. Presiding Justice O'Neill testified that he's been a disgrace to the administration of justice and a disgrace to the Barnstable District Court. At oral argument before the committee, Mr. Haley said he does not seek to go back to the Barnstable District Court. He wants to go to a large urban court, perhaps in Boston. So I think there's agreement. He cannot go back to Barnstable. His reputation is in tatters. In terms of does this court have the authority to assign him to a different court?
That's my question. And not as clerk of courts, as something else.
Well, I was prepared to answer the question on clerk of courts.
Okay, you can do that.
On clerk of courts, I think the answer is no. Under Chapter 218, Section 8, clerks shall be appointed by the governor, and I believe they're appointed for particular courts. And so I don't think this court has the authority to appoint Mr. Powers as clerk-magistrate if there were a vacancy in some other court. Now go to your question in terms of, I'm going to defer to the process. My understanding is that clerk-magistrates hire their assistant clerk-magistrates. From a budget point of view, assistant clerk-magistrates are paid less than clerk-magistrates. I believe there's 62 authorized clerk-magistrates and funding for 62 positions at that salary. Getting a little beyond my recommendation here in terms of court administration and what the budget can handle, but I don't think it would be appropriate. You know, Mr. Powers has been behaving appropriately in the Taunton District Court, is our understanding. The committee's problem is, and with him being a clerk, is his attitude hasn't changed at all. He's been able to conform his behavior, but as Justice Dorfer observed, you know, he still disputes whether he's supposed to be at work at 8:30 in the morning, and he can't be trusted, were he in charge somewhere, to get to work at 8:30 in the morning. Under someone's supervision, I'm not prepared to speak to that, but, you know, this man behaved inappropriately for over 4 years. He willfully, continuously violated this code, and he thumbed his nose at judges and court administrators, and even at the time of the hearing testified he hadn't done anything wrong. I think it would really send the wrong message to send him back to the court system. As your honors know, assistant clerk magistrates in the district court preside over small claims hearings, preside over motor vehicle hearings. Same thing. This is the face of the Justice Department, of the face of the courts. Chief Justice Connolly said that district court is the first port of call for the public.
Gateway to justice.
Gateway to, that's exactly right, Your Honor. That's what the district court is. And to send the message to the public that this man should go back in some other position, I think sends precisely the wrong message about the integrity of justice. That's why I was starting my presentation this morning with talking about the trust that is placed in clerk magistrates, the honor, the authority of the position. I think it would send precisely the wrong message to take someone who has been found to have willfully and continuously violated the canons of professional responsibility for clerks back to any court.
In any capacity.
In any capacity. So I have to keep coming back to the notion that this is a position of honor. It's a position of trust. And the public looks to clerks for honor and trust. And the court, I think, has to keep that in mind. As was observed, Mr. Powers doesn't dispute that he was over an hour late to work the vast majority of the time. He doesn't dispute in his brief that he didn't maintain order and discipline in proceedings and thus violated Canon 3A3. He also doesn't dispute in his brief that he was inattentive to administrative duties of the clerk, such as maintaining a proper bank account for receipt of funds. He admits he was lax in attention to the business of the day. And he also doesn't dispute in his brief that he instructed his staff to backdate his decisions. one of the allegations that the committee made was that he was untimely in deciding small claims court cases. And the issue came up of backdating decisions. And Mr. Haley objected to the admission of that evidence because backdating decisions would be creating a false court record and a potentially criminal act. And the committee took the position, no, we're not admitting it for the purpose of showing he created false court records, but what it showed was that he knew his decisions were untimely.
What do we make of the hearing officer's finding that the committee failed to specifically establish that he rendered his decisions in an untimely manner? The hearing officer relied on anecdotal evidence as opposed to, it sounds like what you're talking about.
Well, unfortunately, we spent a lot of time with the records of the court, and they were not in a way that we could create the statistical evidence. So what the hearing officer relied on was the testimony of a half a dozen staff members who'd worked there for a dozen or more years each, who testified that he was late, who testified that the public would call and ask where the decisions were, who testified that Mr. Powers himself went to them and said, gee, I don't remember what this case is about. Would you call the attorneys and find out to refresh my recollection? Anecdotal, yes, in the sense that it wasn't statistical. Was there a pattern and practice that was established based on the testimony of late decisions? Yes, because you had all these staff members testifying, you had members of the litigants testifying, and attorneys testifying as to the late decisions. The other thing I think that's important to remember here is the efforts made by the court system to help Mr. Powers in what his response was. The efforts were extraordinary. From the very beginning, Regional Administrative Judge Minahan met with him multiple times in 2007, the first year he was appointed. Presiding Judge O'Neill was there to help him, to meet with him. And each time Judge O'Neill met with him, Mr. Powers raised his voice to and yelled at Judge O'Neill. Judge Minahan, after she met with him and told him, you have to be at work on time. You can't treat people like this in hearings. Her impression was, he doesn't get it. He doesn't think he's doing anything wrong. And finally, he meets with Chief Justice Connolly, and she explains to him, you need to be at work on time. You have to treat people appropriately. And his response to all these efforts at help, and his words are perhaps the most damning of all, is he says, these people who complain about me, they're crazy. They're mentally imbalanced. They're sore losers because I ruled against them. There was no sense of self-awareness that could lead to a change in attitude about the people. And so on the notice issue, did this man have notice that he was behaving inappropriately? The answer is indisputably yes. 4 years of notice and over half a dozen meetings.
I'm switching, but I would like to ask you about Mr. Haley's point concerning the denial by the committee of under 7, whatever the rule is, not 7F, but 7B?
B as in boy.
Of the opportunity to appear.
I think the simple answer is in the plain language of the rule, Your Honor. Rule 7B, the second sentence says, within 21 days after service of the sworn complaint or statement of allegations. And this is 7B, and we don't think we weren't going under 7B. But let's assume for Mr. Haley's sake
You never made any affirmative findings to bring it under 7F, did you?
No. No, there was no affirmative findings. We certainly had the right to make, the committee had the right, but did not make those findings, no. But here's the key words. It says the clerk may file a written answer with the committee and may request a personal appearance before the committee. It doesn't say he's entitled to a meeting with the committee.
I mean, don't you think a fair reading of that is that when it's requested, it should be granted?
No, Your Honor, I do not.
Well, why have it there at all, then?
I think the answer is it's giving the clerk notice that he can ask for it. If you look at the case cited...
Then you can just thumb your nose at it? I mean, it just...
No, I think it's not thumbing nose. It's exercise of discretion, Your Honor. In the case cited by Mr. Haley, Reed versus Acting Commissioner of Department of Community Affairs, there was a request. And I went back and looked at the statute at issue. And the statute where the request was granted says, the department may hold a public hearing upon any urban renewal plan submitted to it and shall do so if requested in writing. shall do so if requested in writing. This rule, which Your Honors adopted, does not require a meeting. It affords an opportunity for a meeting. There was no meeting, and there's no harm from a meeting. The issue here is, did Mr. Powers have notice of the charges of them? Did he have the opportunity to select counsel? Did he have the opportunity to present witnesses and cross-examine witnesses? And he ultimately did have the opportunity to address the committee. For these reasons, the committee requests that the court adopt the findings, adopt the recommendations of the hearing officer and the committee, and remove Mr. Powers from office. Thank you very much.
Thank you.